reinforce some issues, and also to bring, for those uninitiated in patent prosecution or thinking about patents, et cetera, it'll be a good foundation for understanding in general terms some of the points that should be reviewed and understood by inventors and those who are dealing in commercialization. As you can see from the slide, my name is Henry D. Coleman. My PhD is in pharmaceutical medicinal chemistry. I have a JD from the University of Wisconsin. My firm is Cont'd Intellectual Property Solutions, PC. We have offices in New York City, in Westchester County, and in Bridgeport, Connecticut. So why don't we, without further ado, let's start the presentation. Let's see. Let's go through this. This is the patent overview. Hang on for a second. I'm just sort of getting, there we go. In terms of patent overview, we first ask the question, what is a patent? And a patent really is it's a property right in some sense. It's an intellectual property right. It's a legal instrument defining an intellectual property right. And it's not a protection of an idea per se, but it protects an idea which is embodied in something that is real. For example, an article of manufacture, a composition of matter, a gene sequence, a method of use such as a therapeutic treatment. It does not protect the mechanism of action itself. And a lot of people don't realize that, although the mechanism of action may be particularly important and helpful for addressing obvious issues as it relates to, for example, pharmaceutical compositions and methods of treatment. Now, what rights does a patent confer? It confers basically the right to sue. By way of an exclusivity to make, use, and sell a claimed invention for the term of the patent, which is 20 years from the original filing date of a non-provisional or an international application. It provides commercial and translation into increased revenues and profitability. Why patent? The economic considerations of patent are clear. Right? Oftentimes, it's the only way to commercialize a product, process, or therapeutic treatment. And very few companies will go to market in the absence of a patent unless they have some other reasons to go into the marketplace. It's the sine qua non for investor group participation and investment. And for universities who rely on investor group participation and venture funds, et cetera, in order to get these products commercialized, it's absolutely critical for that process. By way of the benefit to the university, the patent protection provides revenues to the university and to obviously the UN Rainforest for further research and royalties to the inventions. Now, when do we patent? We patent whenever we develop a commercially viable invention which is new, novel, and non-obvious, and preferably before publication. Patentable subject matter includes new, novel, and non-obvious useful articles of manufacture, methods of making, and methods of using articles of manufacture. For example, methods of treatment, methods of using a composition for a particular purpose. Articles of manufacture can include apparatus, assay systems, flow cytometry, and UNM has been very involved in flow cytometry apparatuses and various methods of identifying compounds using those approaches. Chemical compounds per se, meaning the individual compound, provided it's novel and non-obvious. Chemical compositions, pharmaceutical compositions, admixtures of compositions, compositions of compounds and combination therapies, drug delivery systems, sustained and controlled release systems, etc. Biological products, the proteins, peptides, isolated DNA and cDNA, encoding for proteins, peptides, vectors, plasmid vectors, antibodies, cells, animals, assay systems, etc. As well as methods of making articles of manufacture or producing an intended result. And this is particularly important, for example, for university where they're dealing with new discoveries or repurposing compounds for a particular method of treatment, new synthetic methods and intermediates, methods of producing proteins, peptides, and other biological products, methods of isolating and purifying products, receptors, et cetera. And these are just simply examples of this. The subject matter is extremely broad. Producing an intended result, methods of identifying active agents, using assay systems, et cetera, methods of treatment, therapeutic methods, generally individual indications, although sometimes we can get Marcouche groups depending upon the mechanism of action for a broad group of indications that are somewhat related. New use of old compounds or compositions. This is a well-established patentability position, and the repurposing efforts of old compounds is in fact an example of this. Let's turn to seeking patent protection. Two types of patent protection from a parochial US perspective. United States patent protection and non-United States patent protection. It's noted that each sovereign state has its own patent laws, which may or may not be analogous to the laws of the United States, and you have to be mindful of that when filing for non-US protection. PCT applications have come about as a consequence of an attempt by really some World Economic institutions and various countries to harmonize the various patent laws and ease the administrative burden of filing in numerous jurisdictions. And I'll get into PCT applications, what they are, how you file them, etc., in a later slide. Now I note that most commercially relevant jurisdictions are member states of the PCT, and one can file a PCT application with a priority US or non-provisional US application, and still put in place the filing of an application later on, 30 months from the original filing date of the priority application. Some jurisdictions, however, are exceptions. There are some jurisdictions in the Middle East. Notably, Taiwan and Argentina are not member states of the PCT, and one has to be mindful of that. Those can only be filed with priority 1 year after the filing date of the priority application pursuant to the Paris Convention. Otherwise, most other relevant jurisdictions are filed through the PCT. For United States patent protection in general, the invention has to be useful. It means it has to have utility. It's got to be new or novel, and it's got to be non-obvious. By way of utility, the invention must be useful. The utility has to be either specifically disclosed or inherent to the disclosure of the patent application. By way of novelty, the identical invention must not be found in a single prior art reference, and that could be either a publication or a public use or a poster session, etc. From a non-obvious perspective, the invention must not be obvious over the teachings of the prior art, asserted as an inventive step outside the United States. Novelty and non-obviousness of an invention are always viewed with reference to prior art, and we'll give you a definition of prior art and give you examples of prior art in a later slide so you understand exactly what the scope of that term actually means. Patent applications in the United States are filed as either provisional and non-provisional applications. For non-United States patent protection, the same general rules of patentability apply. Utility, novelty, and non-obviousness apply. The standards and scrutiny, however, vary. Most non-US jurisdictions are absolute novelty jurisdictions, with the exception of about maybe 10 or 11, which I'll itemize in a later slide, which means that you have to file your application before disclosure of the application anywhere in the world. Some jurisdictions, such as United States, Japan, Australia, have grace periods, which will allow the applicant to publish or otherwise put in the public domain their invention, provided it is from them or it is either directly or indirectly obtained from them. Priority applications are filed to establish a filing date based upon a priority application. The international application has to be filed within 1 year of the original US application filing date, either a provisional application or a non-provisional application, and claim priority from that application. Otherwise, if you don't do that, you wind up, you have the potential for losing you lose the benefit of priority, and you have the potential for causing all types of problems by way of prior art being cited against the application. Absolute novelty. US and most foreign jurisdictions are absolute novelty jurisdictions, even though there's a grace period. In the United States, however, the inventor has 1 year after the publication of his or her invention in order to file the application in the United States. Note that it must be the applicant's publication and can't be a publication from another unless that publication was derived from that applicant. Okay, what is prior art? Let's go through that because I think it's important to give an overview of what all these things mean, because sometimes this gets missed, even among people with a lot of experience. Any disclosure of the invention in the public domain is prior art. Publications clearly are prior art as of the date of the mailing of the journal article, and that's less relevant now, or the posting of the abstract or the publication on a website. The submission of an article is not a publication. That's to be noted. Seminar abstracts and conference publications are in fact prior art, as are poster sessions, and you have to be mindful of that. You give a poster session in a meeting, that is a public disclosure, and the evidence that is related to that comes down to what's been disclosed, how sufficient is it, and does it come up to enough evidence to posit that poster session as being viable prior art as against one or more of the claims of the application. Department seminars are generally considered prior art and public prior art, especially if they've been advertised to the public at large, where it's been advertised only in the university and it's narrowly focused. Sometimes that can be an exception to prior art. Thesis defenses are oftentimes prior art, depending upon how they're advertised and how they're presented. Theses also, the same considerations apply. For example, if you have a thesis that is not available to the public in a library, for example, then that would not be considered a prior art and doesn't become prior until it becomes open to the public and can be searched in the library records, etc. Approved grant proposals available through FOIA are in fact prior art. However, many grants have the option of maintaining some sections of that as being confidential, and that would not be construed as prior art. Be mindful of that and always check the boxes to keep things confidential if you can, because that'll prevent the grant from becoming a problem. Public use of the invention is also prior art. And it used to be that public use only in the United States was a problem, but now it's public use of the invention or anything on sale or offered for sale anywhere in the world. So these are the things you have to be mindful of. Commercialization of products embodying the invention anywhere in the world where the invention is on sale or offered for sale are in fact examples of prior art. However, note that the prior art does not apply to licensing. So if you're in a licensing situation with a group and you provide them with some information, right? And you ask them to determine whether or not they can in fact produce something or whatever, and it's not an offer for sale per se, that's not going to be construed as prior art. So when you're in licensing discussions, it's always best to have a non-disclosure agreement and some indication that the particular transfer of information or a device or something along those lines is not submitted as a sale, but is merely provided for licensing purposes. And if it's documented, that would be even better. Preparing and filing a United States patent application, two types of applications: a provisional application and an irregular non-provisional United States application. And there are considerations that apply in each instance to determine whether or not you would rather file a provisional application or a regular non-provisional US application. For all purposes, and I know the universities don't follow this for the most part because of costs and benefits and things like that, you got to assume that the requirements for filing the provisional and the regular US patent applications are identical, all right? That's if you want to claim priority and you want that priority date to hold for all the claims, you got to assume that the provisional application has to be fully enabled and it has to be very detailed in the application that you file. Now, a provisional application is filed principally as a placekeeper and a holder, especially for inventions that have to go through some regulatory approval process for commercialization. The provisional application delays the examination of the regular US application and extends the term. By this, the provisional application gives you a priority date, establishes the date of invention, and also allows you to extend the term to as long as 21 years. Someone who files a provisional application on a particular date and 1 year later files a non-US provisional or a PCT application, which is construed as a non-provisional US application. Oh, excuse me, hang on. Yeah. It allows the subsequent application to have a 20-year term from its filing date. So that gives you the benefit of having an invention date as of a particular date, an application that provides priority for foreign applications or a non-US provisional application. And it provides you with the ability to extend your term so that the term only starts or it's measured from the first non-provisional application or PCT application that claims priority from that application. So that's the benefit. The downside in that is that it'll take longer to prosecute your application. And if you have an alleged infringer or you're dealing with a situation where you really don't have any regulatory approval process for the invention, probably better to not file a provisional application and go with a non-provisional application. Noting again that the provisional application must meet the same statutory requirements of a regular US application, otherwise rights may be lost. This is particularly true in the case of Europe. And I note that in the European Patent Office and the examiners in particular, if they see a US university, they look for the priority application and they look for intervening publications, basically to cite the novelty and invention step issues as it relates to the later filed PCT application. They do this as a matter of course, and given the requirements in Europe as to the disclosure, oftentimes you can get into you can have a problem as a consequence of this approach being taken. Contents of a patent application, let's go through that quickly. A filed original patent application looks similar to an issued patent. In other words, it's identical to an issued patent. If you take an issued patent, you take a look at what it looks like, the application will look like that, look the same as that. However, the claims will be different. In other words, the issued claims are generally narrower or they're fewer in nature than the ones that are originally filed. The most important part of the application is the claims, because the claims defined, wait, hang on for a second. Okay, good. Because the claims really establish the property right in there. It also establishes inventorship. The rest of the application simply provides support for the claims. A patent application must have the following: a disclosed utility, whether that be literal or that be inherent to the disclosure there, an adequate written description of the invention. This is becoming increasingly important both in the United States and outside the United States, because the patent offices are requiring far more examples, experiments, and heft to the specification in order to support broad claims. That used to not be the case at all. You must show one of ordinary skill in the art how to make and use the invention without engaging in undue experimentation. And there's a whole line of case law as to what undue experimentation is or not. But generally, if you have to invent something in order to practice the invention, that will be construed as being undue experimentation. By way of enablement for biological patents and molecular biology, deposit requirement is often critical to the enablement, especially when you're dealing with cells and modified hybridomas and monoclonal antibodies, et cetera. And while the US allows the deposit to be made into ATCC or one of the other deposits pursuant to the Budapest Treaty, the outside the United States, it can sometimes be more rigorous than that. So it's always a good idea to make the deposit before you file the application. It's not critical, but it's a good practice. In the application, oftentimes when you're dealing with an obviousness rejection and critical to getting a patent issued, you need to show unexpected or surprising results in the practice of the invention compared to what the teachings of the prior art would be. Now, it's not a requirement in most instances to have that unexpected result in the patent application, or although some jurisdictions wish you to have at least an experiment or an example and to perhaps allude to that, all right? But it's not a requirement per se. It oftentimes, or it may be, it may assist in seeking allowance of the claims, especially when you're in a situation where there's very close prior art and you have to show a distinction on the basis of non-obviousness. It may be good practice in some instances if you have results that you're fairly confident in, or if you want to take a good scientific guess, is to reasonably speculate on biological activity, which may help assist you in getting a patent, because you can point to some result that's otherwise not in the prior art. So now, I note that synergistic combinations are always considered unexpected results or surprising results, and so one should be mindful of synergistic combinations in each instance. Now, from the standpoint of further disclosure, the best mode prior to the American Invents Act was always required to be put in the U.S. application. And there's a lot of case law that addresses that issue. That no longer is a requirement. And so if you're worried about someone copying directly your examples or whatever, you don't have to put that into the patent application anymore. However, if you're going to file in Canada or some of the other foreign jurisdictions, the best mode requirement is still in place, and that could jeopardize results if you don't put it in the original application. Let's rifle through the examination of a patent application, give you an idea of what generally happens after you file a patent application. Generally, you file a patent application, and if everything is up to snuff and there are no problems with, for example, the claims, the filing fee, or the figures, the application will be sent to an art unit and to an examiner for examination. If there are issues with those things, then you'll get a notice to file missing parts, in which case you will have a couple of months, which can be extended, to address the missing parts that the patent office has identified. This notice to file missing parts with this approach is it's very common in continuation and divisional applications, where you may not have decided which claims you want to prosecute in the divisional, the continuation application. So what you would do is you would file the application without filing the fee, get the notice to file missing parts, and that'll give you a couple of extra months to identify which claims or which invention you want to focus in on in the continuation or divisional application. Once the application is filed, you get past the notice to file missing parts, the application gets assigned to an art unit and an examiner. The examiner conducts an initial search of the prior art. The reason why they conduct the search of the prior art is even if there's a restriction requirement that's made, they want to have at least one piece of prior art cited to show why you don't have unity invention, and you have to restrict the case out. In general, applicant has to cite known prior art to the examiner, and that's in all instances, and that pertains to both the inventors and to the attorney or patent agent who's involved in the application. And make sure all the relevant art known is cited. There's tension between the number of references you cite and then someone contending that you buried the examiner, but you just cite whatever you think is appropriate and you go from there. When you're in a litigation, there's no way of anticipating all the issues that'll emerge, so you just try to do the best job you can on these sorts of issues. After the restriction requirement and you choose your invention and you choose your species, all right, the examiner issues the first office action. In the case of restriction, more than one invention is cited, and you're forced to take or choose one or more of invention groups or species associated with those invention groups. And you can make arguments to try to avoid that or to traverse it. They will oftentimes not take it. If there's a PCT application, you can argue that there's already been an international search report, et cetera. But depending upon the examiner, you may or may not be able to get them to sort of group more than one invention, group more than one species in a particular application. I note that if you're restricted out and you have to cancel claims, you can file one or more divisional applications directed to that subject matter. You do not lose any of the subject matter unless you decide not to file divisional applications. In the first office action, that's not a restriction requirement. Oftentimes there'll be a rejection of the application on statutory grounds, whether it be formal rejections or substantive rejection. And the applicant then has, as a general rule, 3 months without an extension to file response to the office action. The response can oftentimes is generally you're given 3 months additional extension periods to file a response. In responding to the office action, there are two types. There are formal rejections or objections. These are minor, generally easily addressed rejections or objections related to form of the claims, form of the abstract, typos, some type of language objection, periods missing, things like that. And those are easily disposed of. Then there are the more substantive rejections, two types: an insufficiency of disclosure, enablement issues in written description, which occurs under section 112, first paragraph. And then you have issues related to the substance associated with their it being non-inventive, the claimed invention being not invented over the teaching of the prior art, whether that be an anticipation, no novelty, where the invention is found in a single prior art reference, or it's obvious over the art, meaning that one or more art references is combined, those teachings, in order to make that rejection. The applicant responds. You can defeat insufficiency of disclosure by showing enablement and written description using teachings in the specification or the prior art. Enablement is generally not that onerous an issue. For most claims, depending upon the breadth of the claim. Written description has become more of an issue for the patent office, principally because they don't want to give you broad claims anymore, or they try to narrow the focus of the claim, and that's where they sort of focus the attention of their rejection under section 112. You can get past that by having an adequate description. Oftentimes the patent office, and increasingly, the patent office does not want to give you generic terms and claims because of the breadth of that. And because oftentimes those types of claims read on future embodiments, which the patent office is loath to give, but sometimes you can get decent claims if you have enough description and you can convince the examiner of that. You can defeat an anticipation rejection and just simply show the invention is not found in a single prior art reference. Sometimes the examiner gives you an inherency rejection where it's unclear whether or not a particular example really provides the same invention as you're claiming. And what the examiner will do is the examiner will say that by practicing the example or by practicing the specification, you'll inherently produce the same invention as claimed. And there you're going to get into a situation as to how to address the inherency, oftentimes by experimentation, sometimes by showing from the prior art that it doesn't, that doesn't exist. Intensive rejections to address. You're generally addressing a combination of references, and you're saying that it does not teach the invention. So the examiner comes back and says, this is obvious because there's motivation by a skilled practitioner to practice the invention with an expectation of the results that are claimed, right? And perhaps the easiest way of addressing this is to show that the combination of references does not teach the invention or teaches away. This can be done by showing the prior art. Sometimes it can be done in just in the references that are disclosed, but oftentimes you can find some decent prior art that you can combine to show that the skilled practitioner would not even try this because they would expect that the product would not even, or the process would not even occur, or would not provide any results. Barring that, and barring the ability to dispose of the motivation issue, the next step would be to try to claim that the invention represents an unexpected or surprising result. And when you're in this process of dealing with the patent office on these types of rejections with this type of evidence, you're in the reeds or the marshland of the patent office and dealing with the examiner, because this is where the evidence comes up, and you're going to be in for a long slog in many instances to try to get the case allowed. It just depends on the nature of the invention and the closeness of the art as to how much evidence you have to put in order to show that your invention is unexpected or surprising. As I said, in the case of synergistic results, those are clearly unexpected, and the patent office will take them. Where there's no synergistic results, then you're going to have to basically get into the reeds and the marsh of the evidence in order to show that a skilled practitioner would not consider this expected. Now, there are, in addition to these types of evidence, there's also secondary considerations in obviousness that provide a basis to traverse an obviousness rejection. For example, if you can show that an invention meets a long-felt need in the art, or there's been no contemporaneous invention despite intensive research or incredible capital that's been committed to the type of project or type of invention you're dealing with, that's a way of dealing with it. The fact that there were tremendous efforts by others and failed to come up with the same invention, or that others in the art view invention with considerable esteem, declaration from colleagues, and commercial success in the invention. All of these secondary considerations can go into and assist in traversing an obviousness rejection. But here, as I said before, when dealing with these sorts of issues, you get into significant capital expenditures and expense to marshal that evidence to get those claims allowed. By way of, let me just make sure I didn't, yeah. By way of policy and practice in the USPTO, the things that we can take away from that are that it can be difficult to have broad claims issued without experimental support as to breadth. And so if you're going to go after broad claims, you better bulk up your patent application considerably and spend the capital to try to put that together if you want to get a fairly broad claim. Now, obviousness rejections can rely on the experience and general knowledge of the routineer or the skilled practitioner. It used to be that was not the case. Case law that's come about since like 2011 shows that an examiner can just simply impose the understanding of the examiner's knowledge of what the skilled practitioner understands from the prior art in order to make that rejection, and doesn't have to be any documentary support. And again, if the examiner makes that argument, you're in the reeds or the marsh of obviousness, and that's a difficult rejection to reverse, although it can be done. There are many more inherency novelty rejections in the Patent Office. The Patent Office wants to see experimental support for non-inherency. Oftentimes, they will cite or reject an application based on inherency and shift the burden to the applicant to capitalize the experimentation necessary to prove non-inherency. That can be onerous at times. There are many more restriction requirements and species limitations. That's something you just have to deal with. If you've done a PCT application and there has been at least one international search report, or if you're in a continuation application and there's been multiple searches conducted, you can argue that the examiner is not under such a burden as in the earlier application to try to defeat a restriction requirement or a species limitation. Nothing to take away is the review of patentability decisions by review committees is now relies in the Patent Trial and Appeal Board, the PTAB. So in other words, anything that goes from an examiner or a post-issuance issue on a patent goes to the PTAB in the first instance. If you're not happy with the decision there, you have two alternatives. One is to go to the district court in the Eastern District of Virginia to appeal that, because that provides more flexibility than the Federal Circuit, principally because you can actually add evidence in the Federal Circuit case, in the district court case, but that can be appealed to the Federal Circuit. It also can go to the United States Court of Appeals for the Federal Circuit, but there the evidence is limited to the evidence on the record in the Patent Office. Key patent issues for the life sciences, just in general, some bullet points. File a provisional application before you publish, preferably meeting all the requirements for patentability. Cost and timing are obviously an issue. Most of the universities I deal with rarely file a provisional application that meets the statutory requirements or is as detailed as is a PCT application or a U.S. non-provisional, principally because of the cost and because they're trying to capitalize various number of inventions, and they don't know which is going to work or not work, so they'd rather avoid the cost at that time and spend it later on if they decide to go in with a non-provisional or PCT application, especially if there's a licensee that comes to the table. Make sure the application has sufficient support and claims, the invention detail. Claim appropriate breadth for the invention, avoid claims which are invitations to experiment. Patent office, if they see that, they'll give you enablement rejection instantly. And if it's a written description issue where you have a very, very broad generic claim or broad generic term in a claim and you can't support it with the specification, you're in for a battle there. The description of the invention must support the application in chemical syntheses, support the application with individual species. This is particularly relevant in the case of methods of synthesizing compounds, because there you not only support the breadth of the synthetic method, but each of the individual intermediates and precursors can be patented themselves, and they can represent nice choke points on a method of synthesis if someone tries to practice the invention. In biotechnology, patent applications provide an adequate enablement written description, particularly critical here where terms are used or general concepts are used to define terms as opposed to specific species. You need to support the breadth of the claims with a significant amount of rigor in order for those claims to pass muster. General rule is to provide as much disclosure as possible and hope for the best. These are fact-driven inquiries. Further key patent issues, which I think are common sense, some of them common sense, some of them not. Don't disclose the invention to anyone until after you've actually filed the application. Document the invention, principally for inventorship issues. It used to be that your date of invention was determined by the concept and the evidence that established concept, or established conception. But now the documentary evidence really is associated with inventorship issues and derivation issues, and it's still important, but is not as critical for the invention date. When conducting the research, document inventions in notebooks and put in read and understood. And even though this goes back to the old practice, the interference practice, it's still good practice now for the inventorship questions and for the derivation issues that occur post-issuance. Here's another feature that's very, very important. Document and memorialize group meetings. This is where the rubber meets the road with respect to inventorship and the battles that occur between the inventors and colleagues, especially in university settings where there's a lot of go-between the individuals, and some of it may come up to the point of it being a conception, some of it may not, and you have to be able to address that with clear and convincing evidence in order to have the issue disposed of. Another issue, just I mentioned, is material transfer agreements and agreements to share compounds or methods or whatever, do some things in the assays. If you are sending a compound or you're sending something to a colleague in another university, and there's a risk that you perceive that that colleague may in fact take your material outside the bounds of whatever the material was disclosed for and put it in their own assays or whatever, and their own processes, they may file patent applications directed to methods of treatment or whatever based upon their own work with your compound or from a material safety agreement or a material transfer agreement. So in that instance, it would probably be good practice to anticipate the potential for an invention made by by simply sending out a compound for testing and put in your own provisional application directed to a concept that would be likely to occur if, in fact, that university that you're transferring it to or that institution you're transferring to comes up and decides to be a little bit more creative about it than for what the material transfer agreement was, in fact, transferred for. Let's turn to the American Invents Act. This was now, it's a little bit old hat. It's now almost 10 years old. When it was signed into law, the effect, some of it was 8 years, 9 years, but the Leahy-Smith American Invents Act had a certain list of changes and changed the practices from those applications that were filed earlier than 9/16/2011, and some instances later than that. So a lot of the old practice still applies. Much of the new practice is now been changed by the American Invents Act, and here are the list of the changes. We've gone to a first to file system as opposed to invention date system. The prior art definition has changed. There's a grace period to disclosure. There's pre-issuance issues. There are fee increases. Well, there's always fee increases. I don't know. We're dealing with micro entities, which is a new status of the application for purposes of determining fees. We've gone to prioritized examinations. We've maintained third-party submissions where one can cite prior art to an examiner, even though you're not the applicant. Then there are post-issuance issues. They maintain existing procedures such as ex parte reexamination and reissue. They've basically changed inter partes reexamination to inter partes review. There's now a post-grant review, making it less onerous for a non-applicant to challenge the patentability of a patent that's just recently issued. There are derivation proceedings, which really are substitute for the interference proceedings, and establish can establish a date of invention earlier than a patent application if you can show that someone derived their invention from your invention. There's supplemental examination, which is a little bit softer version. Rather than go to re-examination, a patent owner can simply ask an examiner through this procedure whether or not there's an issue of patentability that needs to be addressed in a re-examination proceeding. And then there's third-party submissions where post-issuance or even litigation, one can take statements by the applicant that are made in other venues and cite it as a record in the patent office to determine claim scope and other issues. By way of litigation, there's now prior use definitions where anything that's on sale anywhere in the world or disclosed anywhere in the world now applies. There's no best mode requirement, and by way of false marketing, there's no false marking or forced marketing for any label that has an expired U.S. patent on it. First to file, it's a first to file system. AIA changed the formerly the first to invent to a first to file. This is consistent with patent laws throughout most of the world. Of course, there's now the first to file, the first to file, but there is the exception in the form of your ability to hang on, I thought I forgot my train of thought. It's a first to file system, but you have a grace period to address some of the concerns associated with the first to file system as an exception. And I wanted to note that Lisa was very instrumental in dealing with this particular issue, in getting that particular exception promulgated into that law. The first to invent system gives priority to the first to invent, and that was the old system. It's still in place for applications that were filed earlier than 2011. Evidence supporting the conception of the claimed invention prior to the filing date is considered to be determined the first inventor of the application. This first to file system gives priority to the application, so get things on file. So the first to file gives priority to the application with the earliest filing date. Now, the effects, the applicants would no longer be able to rely upon an earlier date of conception when prior art has an earlier date than the effective filing date if the prior art is not their own. An inventor who waits to file an application may risk losing his or her patent rights to an inventor who invented later but filed first. Noting that you've got the grace period, that's the exception as part of this rule. Definition of prior art was changed. Novelty prior art is any prior art that's filed before or is published before the filing date of the applicant's file. It's filed before the filing date of the applicant that is not related to the patent application that's been filed. So if a third party files a disclosure and it's filed before the patent application filing date, you're out of luck. That's going to be prior art. If it's your own prior art, or it was derived directly or indirectly from the applicant or the inventors that have filed their application, then one can in fact predate that disclosure by using your conception and invention date to get behind that in a sort of a quasi grace period, and that's too okay. The effects are the date the prior art is effective to determine by the earliest effective filing date is the first to file now, and the inclusion of the language otherwise disclosed to the public means that the publication anywhere in the world, the public use, a poster session, something that's been on sale, or a thesis anywhere is going to be sufficient to potentially invalidate a patent. As I said, prior public use or prior sale anywhere qualifies as prior art. It used to be only in the United States. In terms of the grace period, we discussed that a little bit. Disclosures that are made 1 year or less before the effective date of the claimed invention that are made by the applicant or by an individual that derived their publication or the substance of the publication directly or indirectly from the applicant are not considered prior art. You have a grace period to predate that prior art. Let's see, the effects are an applicant can only swear behind a disclosure when the disclosure is made 1 year or less before the effective filing date. And as I said, the disclosure must be made by the inventors or another who disclosed the subject matter directly or indirectly from the inventors. And therefore you get around, if it's a third party, you're out of luck. Prioritized examination has been something that's been considered more frequently recently since AIA, and prioritized application now be obtained for utility and plant utility applications. USP states the goal is to provide a final disposition within 12 months on average of prioritized status being granted. They maximize 10,000 requests per year. The cost is $4,800 for a large entity, $2,400 for small entities. It may be particularly relevant in cases where commercialization or potential infringer is in fact out there, or you have a licensee that wants to see the application issue, or you have other commercialization issues that may be important here. In prioritized applications, you can't have any more than 4 independent claims and 30 claims total. Obviously, you can have less or fewer. And the patent office attempts to have the entire application disposed of by way of an issuance or a final rejection within the 1 year period. Also, the USPTO may provide for prioritization on the basis of national security and for other reasons related to national competitiveness or issues related to the importance of the national economy. Initial observations were that the back in like 2011 through 2014, 2015, the prioritized application examination actually slowed up the examination in some respects. But since then, it's gotten much better, and they're able to dispose of these examinations far more efficiently. By way of third-party submissions, Any person at any time may cite to the USPTO in writing any printed publication or patents or prior art that they believe impacts the patentability of the claim. Submission is the same it used to be under the old law. Most attorneys won't use this because it really is relatively ineffective at influencing anything in the patent prosecution. However, statements, the AA established that statements of the patent owner filed in a proceeding before a federal court or a post-issuance proceeding can be filed in the file history in order to influence the claim scope that ultimately is determined in the litigation, or to define the patent claims more specifically. And that's helpful. A lot of people have taken that up. Let's go into international applications. International applications to establish priority of a U.S. provisional and non-provisional application. Paris Convention, you've got to file that within 12 months of the original priority application directly into the individual jurisdiction. It may be only relevant today to Taiwan, Argentina, some of the Middle Eastern countries, and perhaps some of the South American countries. Patent cooperation treaty is the way to go. Everyone tends to file under the patent cooperation treaty. That's filed no later than 1 year from the earliest priority application. Designates by default 153 member states, most of the commercially relevant jurisdictions. And it allows an applicant to hold the filing of a foreign application in abeyance or delay the filing of these national phases until 30 or 31 months after the filing of the original priority application. And that provides 2.5 years really to either get a licensee or to find someone who might want to commercialize, et cetera. And it allows a significant delay in this whole approach. And that was the principal basis for it being put together in the first instance. We went through this slide that in the United States patent protection, same rules of patentability apply. And most of these jurisdictions are absolute novelty jurisdictions. I do indicate here grace periods, and absolute novelty is applicable anywhere in the year, anywhere in the world. But the same approach to the grace period that exists in the United States also applies in Japan, Mexico, Argentina, Australia, the Philippines, South Korea, Brazil, and Singapore. Here are the member states of the PCT. You note that it covers most of the world with the exception of a few outliers here. As I said, they indicate Taiwan is part of the PCT and it's not. Argentina and Taiwan are pretty much the only really commercially relevant jurisdictions that you should think of in filing within a year. Rather than doing a PCT. A couple of considerations for PCT applications. Important features at the time of the application. Choosing the search authority is important. Cost competence comes up. The Russian search authority is now the most cost effective, and so that's what we tend to use. It gives you a second bite of the apple because in other words, the search reports that are there are very, very effective. The Russians tend to be bilingual. They search a lot of literature and a lot of the exotic technologies that the West doesn't really go into, like a lot of the electrochemistry, a lot of the physical chemistry. The Russians handle very, very competently, and it's a jurisdiction to go to. And they do a lot of good. They do some good work on the life sciences as well. So that's a first pass, and it makes a lot of sense to do it that way. During the international application phase, you got to deal with the invention, cost for additional inventions. Amendments can be filed under Article 19 right after the search report, and Article 34 pursuant to the written opinion. Most attorneys don't do amendments to the PCT application because it's not cost effective, and because the standards do differ in different national phases or different jurisdictions. Oftentimes, it's not necessarily advisable to do amendments during that phase. You can amend the applicants and inventors to the PCT application, and preferably during the PCT application. And in the event you change the inventorship, get non-pro-tunc assignments, which establish that the assignment was made no later than the earliest priority application that the inventor was associated with. Here's national phase filing dates. And whether or not, if you blow the date, it's flexible to get it back or not flexible to get it back. I'm not going to go into great detail on that. These are some of the non-U.S. filing principal considerations. I'm going to go through this really quickly. You can read that for yourself. And then the national face, the individual jurisdictions. These are the basic points that one can take from most of the commercially relevant jurisdictions that Big Pharma will file in, or a lot of the patent groups will file in: China, Japan, Eurasia, Russia, India, Brazil, Australia, Indonesia, Malaysia, Canada, and Mexico. I'm going to stop this now because I want to, if you have any questions, we can then take the questions and go from there.
Thank you, Henry. Do we have audience questions? I was curious, Henry, if if we have any data about who's using these prioritized examination requests. Is that mostly big companies, or do we have any data?
It's all. I don't have any data specifically. In my practice, it's been if there's basically if it's a university invention with a licensing group that wants to know whether or not something's patentable for purposes of investment, they'll do a prioritized application. Some big companies will do it if they think that there's an infringer that's out there. But oftentimes, if we're dealing with pharmaceutical applications, there's no need to do the prioritized application, principally because they're dealing with a regulatory approval process and they're not that concerned about it. It's mostly venture capital group, investor groups, in my experience, but I don't have any data from the patent office that tells you what they are.
Okay, I guess that makes sense. In the pharma world, you actually, well, maybe it doesn't matter nowadays with the 20-year rule, but I was thinking maybe you don't want the application to issue, but I guess that would only be for continuations.
No, even a continuation has a term as of the earliest priority date. So whenever the priority date was filed, your turn is going to be 20 years from there, with adjustments for patent term extension and patent term adjustment. So it just depends on what it looks like, and what you're trying to cover and what your FDA approval process looks like.
Other questions? Okay, here's a question. Can you discuss limitations on patenting biological discoveries with respect to laws of nature, natural correlations?
Yeah, the problem there is that if the patent office perceives or construes your invention as a law of nature or something that is that occurs naturally, they're not going to give you patent protection on that. So the way to dispose of that is to have an active step or have an element in addition to what the law of what the natural phenomenon is, that's not part of the law of nature, or is not part of the natural product. And depending upon what that element is, provided that it's novel and non-obvious, you generally can skirt that issue. So for example, if you have a method of treatment that the patent examiner construes as a law of nature by putting in an active step of treatment or something along those lines, like for example, in diagnostics oftentimes have this problem. And so what you do is if you put in an active step of treatment, you oftentimes can circumvent that issue. And that's how it generally gets disposed of.
Okay, thank you. Other questions? I have one about the patent term.
Yeah.
Now that we have 20 years from the date of application, the non-provisional application, what are the pharmaceutical companies and biotech companies doing to enhance that? Because that's really a pretty short time frame for them.
Right. Well, you have to understand that they get patent term extensions from the FDA regulatory approval process, which can be as long as 5-6 years. It's a fairly complex formula that the patent office has for determining the extension. I note that you can only extend those claims that read on the particular product that went through that process, that regulatory process. And what the way the patent office is, the way the big pharma or the pharmaceutical companies, the biotech companies are dealing with it, there's a lot of formulation patents, meaning that they have a general thing. Now they have an intravenous formulation that has unexpected results, or they have a particular salt that has a particular result. So they deal with a lot of polymorphs and things like that to address the term and to try to extend the monopoly somewhat.
So they're basically kind of like improvements, things that they can.
Minor improvements, a pinch of this and a pinch of that, and they try to get a patent on that. It's very narrowly focused on the product that they're selling. Whereas the basic patent protection might be much broader than that.
Mm-hmm. Which is typically where the university's patents are.
Yes.
We have any other questions? Put them in the chat or feel free to ask them in person. Oh. Okay, Patricia.
Hi.
Hi.
So I missed the very last point you made about where universities usually are. I'm sorry, but that is an interesting area. So could you repeat the answer to that?
That had to do with the patent term extensions, and that's usually done by the companies who are actually selling a product by that point.
Right.
Versus universities who are filing the more basic inventions.
Got it. Okay.
Right, Henry? Isn't that what
there are two ways of extending the term of a patent. The first is the patent office procedure. They tend to be dilatory or whatever. And what they do is at the end of at the point when it becomes issued, they look at the patent, they look at the prosecution, and they may give you extra days because they didn't conform to their own internal expedited process for that. That's distinguishable from the patent term extension, which is an extension you get for the delay in approval for commercialization by way of a regulatory process. So if you're going through the FDA and it takes you 6 years or 10 years to get through the FDA, there is a process and there's a formula the patent office applies to claims that read on the regulatorily approved product or process, and you can get a patent term extension of 5-6 years for the claims that read on that particular product or process.
Got it. That makes sense. Good. Thank you. Thank you.
Any other comments or questions for Henry? Well, I'd like to thank you, Henry, for spending the time with us today and giving such a detailed explanation very clearly about all the nuances of getting a patent, which seems to be getting more complex all the time.
Yes.
So we appreciate that very much. And thank you, everyone, for attending the seminar today.
Thanks much, Lisa. Take care.
Bye-bye.
Yeah.